We were informed that they filed a notice of appeal to appeal the magistrate decision, finding that they are extraditable. It so happened that the prosecution services in Eswatini realized that the notice of appeal so filed was null and void for reasons of being filed out of time, and further, it was filed after the Minister of Justice has already given an order for those two South African citizens to be brought to South Africa. As a result thereof, an application was brought by the prosecution services in the High Court in Eswatini for the High Court to declare the notice of appeal being null and void. The two Ndimande brothers opposed that application. The judgment or the ruling thereof is today. It will be delivered at 11:30. That is the correspondence we have received from our Eswatini prosecution team. Mention needs to be made of the following. Mr. Dlamini, who is appearing for accused number 1 in this matter, is an instructing attorney for those two Ndimande brothers in Eswatini. And his law firm instructed Advocate Mlochwa, who is also present in these proceedings, to argue the opposition of the state's application for the declaration of the notice of appeal being null and void. Mention also needs to be made of the fact that the prosecution team indicated to us that we were informed that they filed a notice of appeal to appeal the magistrate decision, finding that they are extraditable. It so happened that the prosecution services in Eswatini realized that the notice of appeal so filed was null and void for reasons of being filed out of time, And further, it was filed after the Minister of Justice has already given an order for those two South African citizens to be brought to South Africa. As a result thereof, an application was brought by the prosecution services in the High Court in Eswatini for the High Court to declare the notice of appeal being null and void. The two Ndimande brothers opposed that application. The judgment or the ruling thereof is today. It will be delivered at 11:30. That is the correspondence we have received from our Eswatini prosecution team. Mention needs to be made of the following. Mr. Dlamini, who is appearing for accused number 1 in this matter, is an instructing attorney for those two demanded brothers in Eswatini. And his law firm instructed Advocate Mlochwa, who is also present in these proceedings, to argue the opposition of the state's application for the declaration of the notice of appeal being null and void. Mention also needs to be made of the fact that the prosecution team indicated to us that even though they, as the prosecution team, indicated the agency of the matter because of these matters in South Africa, the Ndimande brothers in their papers indicated that there was no agency. With that brief history then, Your Worship, we wish to indicate to the court that the extradition process is at the stage that it may reach its finality today. And if one has to weigh the interest of justice, in the next perhaps week or so, they might be joined in this matter. The state did not hide the fact right from the onset of these proceedings of the existence of provisional arrests and the arrests and the proposed extradition process that was unfolding. When the matter was adjourned until today, we catered for this process to unfold to its finality. And we were of the view that by the 29th of November, it would have been finalized. With that being said, may I stress the following. The prosecution services at Eswatini, on the request from the Republic of South Africa, did everything possible to have the two Ndimande brothers brought to South Africa. The first leg thereof was the Magistrates Court, which granted the application for the extradition. The judgment is there. Despite some delays, further thereto, the administration of the Kingdom of Eswatini, through the Minister of Justice in that country, issued an order that they should be extradited to South Africa. As we stand, they should be brought to South Africa. Enjoying their rights to appeal, a notice which appeared to be null and void was filed, which became a subject of a High Court matter, which ruling is coming out today. We therefore request that this matter be adjourned to allow the addition of the two demanded brothers as accused number 3 and 4 in this matter. But before I propose the period thereof, Your Worship, perhaps I should allow my learned friends to address the court on the request for the postponement at first. Oh, just before. Oh, another aspect that I forgot, Your Worship. My apologies to interrupt the court. Accused number 2, as I earlier indicated, brought an application and is entitled to a ruling of that application. So for those two reasons, we request the matter to be postponed. Your Worship wanted to ask me something.
Yes, and I was saying that the ruling on the extradition outcome is due in a few hours' time.
In a few hours' time, on whether the notice of appeal is null and void. The ruling that they are extraditable is there. The magistrate ruling is there. Thank you. Unless there's anything else, we should close out my submission.
May it please the court, my instructions are to object to this statement. Your Worship, my instructions are that to remind the state of the nature of our constitutional democracy, in that the Bill of Rights serves as a cornerstone of that constitutional right. In fact, Your Worship, in particular today, is Section 85 of the Constitution. The right to a fair and speedy trial. That right, Your Worship, stands today, has not been suspended by anything. court needs to be reminded again that in respect of this matter, it is marked final. Final for investigations. And for the state to give indictments today. Also as a background, Your Worship, we were given to believe that those two demanded boys in Eswatini are not needed for proceedings going further against these two. We are well aware that judgment is to be given within the next hour. But I believe my learned colleague from the state has put the ball before the cart in that he also fails to mention that it could go either way. The High Court judge may say that the two-man demanded brother may proceed with their application for appeal. Secondly, I need to place it on record. There's still another avenue that those two demanded brothers have not taken, in that should the matter, the judge decides that the appeal is null and void, that decision itself is appealable. What then happens with two accused that are here in court sitting for a period of over 9 months? And I need not remind the court of the directives in respect of the court roll. It's already been 9 months into the court roll, and it seems as if this matter is not going anywhere. What then happens when the demanded brothers lodge an appeal? Are the accused before court supposed to wait another 3, 4, 5 months before that process is finalized? I submit, Your Worship, that the adjournment that the state is seeking is very prejudicial to the accused before persons. They must do the honorable thing. They know where to find the accused persons. Should the matter finalize in Eswatini, they can be summoned back in court. It doesn't mean the matter goes away. In that respect, Your Worship, this court issued a directive that this matter is final. And final means final, Your Worship.
Thank you, Your Worship. Your Worship, I likewise stand on instructions to oppose a further remand. The basis for the same is that Your Worship had made a ruling on the last occasion that the investigations be finalized by today. That ruling was based on previous submissions by the state that they had their house in order, and that by today not only will the investigations be complete, but the state would be ready to indict the accused to the High Court. Now clearly, Your Worship, just from that position itself, indictments cannot be prepared because the state does not have its house in order. The state not having its house in order is prejudicial to the accused. More so with accused number 2, although it's been placed on record that judgment is to be delivered on the 17th of December, accused number 2 was trying to move that bail application from about the 16th of July. So there's double prejudice, Your Worship, not just to say that he's entitled to get a ruling in that matter. The fundamental principle echoed and with the basis in the Constitution, particularly Section 35, subsection 1F, is liberty rights, not so much fair trial rights. This is a bail application. But we are dealing with the liberty rights of the accused. When that is being assessed, one of the factors, the most crucial factors, is prejudice. I submit with respect, Your Worship, that this would be prejudicial. Alternatively, another aspect, Your Worship, is that I'd like Advocate Kaba to indicate the length of time that he is seeking this adjournment, because if it's next week, the prejudice is less. If it's next year, the prejudice is more. If it's next year, March, April, May, the prejudice is intensifying. So those are the factors, Your Worship, that need to be placed on record for Your Worship to deliver a value judgment on this application. But those are my basis for objecting, Your Worship. Thank you.
Mr. Minister asked that he interprets it before I reply.
Kule cala nibhekene nalo ke la ngamabili umshushisi kufanele wena faka isicelo sebheli kusukela ngo-October. Isicelo sakho sebheli inkantolo izokunikeza isinqumo sakho ngomhla ka-17 Disemba. Wabekeza echazela inkantolo ukuthi-ke kunabantu-ke besilisa Eswatini ababili bakwadimande okwafaka isicelo sokuthi-ke mabalethwe la eSouth Africa bezojoyina kuleli cala enibhekene nalo. Inkantolo lapha manje yasikhipha isinqumo sokuthi-ke bangalethwa, kodwa-ke base-ke benze njani, badlulisa-ke bafaka isicelo sokuthi-ke bayi-aphile leyo sinqumo senkantolo manje yaseSwatini. Kwabeke sekutholakala ukuthi ngaleso sikhathi-ke isicelo sabo noma-ke amaphepha bawafaka ukuthi bafuna ukuyidlulisa leso sinqumo leso bawafaka sekudlule isikhathi kwase kuthiwa-ke amaphepha angasishumi. Lokho-ke base beyakudlulisa-ke beyocela-ke emjajini eSwatini ukuthi-ke uthathe isinqumo sokuthi-ke bafisa ukuqhubeka nesicelo sabo. Isinqumo sejaji-ke lapho sokhishwa namhlanje ngabo-11:30. Umshushisi kube secela ukuthi-ke inkantolo-ke imuphe ithuba lokuthi-ke lecala liphinde lihlehliswe namhlanje. Yize kakade kuthiwe-ke namhlanje-ke uzobe sekugcina umseshi ekunikezwa ithuba lokuqeda uphenyo lakhe nayo yonke into ephathelene necala leli. Kodwa-ke isicelo sakhe enkantolo ukuthi-ke inkantolo inikeze ithuba lokuthi-ke kulethwe labantu baseSwatini bazojoyina kulina leli cala leli, nanokuthi-ke wena-ke ulinde isinqumo sakho sebheli ngaphambi kokuthi iqhutshwe naleli cala leli. Abameli-ke bakhilisile lokho. Mr. Dlamini-ke ukhala kakhulu ngendaba yokuthi kuzokwenzeka kanjani uma kuwukuthi namhlanje isinqumo saseSwatini sithi-ke ondimande baqhubeke nesicelo sabo leSwatini. Kusho sifuneka kuphinde futhi kulindwe ezinye iy'nyanga noma amasonto kungaziwa ukuthi bazolethwa nini la enkantolo. Nowakho umeli ukhala ngento efanayo ukuthi-ke inkantolo ngaphambi kokuthi ithathe lesi sinqumo lesi kumele yazi ukuthi ikhathi ngigcina ukuvela la enkantolo kwakade kuthiwe namhlanje icala leli kuzofika umshushisi esephethe amaphepha ukuthi-ke ukuthi liyoqulwa lihanjiswe le-high court icala. Akushiwo nokuthi namhlanje nize la ukuthi-ke nizolinda ukuthi nijoyine nabanye abantu. Uma bekhona abantu abazojoyina kuleli cala-ke makuwukuthi-ke liyaqhubeka icala bangafaka noma nini leli cala. Akusho ukuthi funa nihlale la nilinde kungafiki emaphethelweni sekudlule inyanga eziwu-9 niboshelwe le cala leli. Akaze umnyakazo khona, akaze kusho ukuthi liyoqula icala, akaze ukuthi kwenzakalani.
Thank you, Your Worship. I'm a bit.
I've got a question to pose to both the prosecution and the defense. That what is the big deal about a postponement in this matter? One applicant, accused number one, is out on bail in this case. He's out on bail in this case, so there is no issue of anything. He is out on bail. Accused number two is in custody. He's waiting the outcome of the bail application, which matter is postponed to the 17th of December. So in this matter, not the other matters, but this matter, what is the big deal?
May it please the court. Do concede that accused number one is out on bail. But the prejudice that he's suffering, Your Worship, is that of financial. There's a further adjournment he's paying for his legal fees. And I say the prejudice that he's suffering outweighs the prejudice that the state will suffer.
Bail in this case?
That is correct, Your Worship. But he is paying legal fees today for this matter to be finalized for indictment. And the state is seeking yet another adjournment. Who is going to cover those fees? There is material prejudice, Your Worship, that he is suffering.
And just to add, Your Worship, while we on the aspect of prejudice, is that Advocate Kaba has still not indicated to the court how long is the adjournment that he is seeking. Because like your worship says, accused number 1 is already on bail. Accused number 2 has a decision pending which will be delivered on the 17th. Now on the 17th, if that goes against him and he's now got to sit in custody till April or March next year, that is why I'm emphasizing the time of the adjournment. Because your worship, I submit with respect.
March next year.
Well, we haven't heard yet, your worship. We haven't heard how long this adjournment is going to be. What we have heard is that the ruling will be delivered in an hour's time or so forth. So that could facilitate us coming back next week or in 2 weeks' time. And this is why, again, I'm emphasizing the time frame. Because then the prejudice would be minimized. Because if we come back in 2 weeks' time, and depending on that decision, and if there's an appeal, and then it's going to delay it another 3 or 4 months, that impacts on prejudice, particularly in respect of accused number 2. So those are the factors. It's a simple question, Your Worship, just for him to answer.
Thank you, Worship. May I mention this so that moving forward we are clear?
Maybe before you mention whatever you want to mention, why is the matter brought now before the judgment at Eswatini, which is due in hours' time? Why was the matter not delayed until that judgment comes out so that we'll then talk about a judgment has already been given, this is the judgment, and we apply that this court do 1, 2, 3?
We thought of that, Your Worship. We thought of that. However, this matter, this present one, that is the second leg of the application. Remember, there's a judgment on the 17th that needs to be catered for. That is why this matter was called first, because there are 2 legs of the postponement. Firstly, let's finalize the bail. Secondly, let's join the other 2. But I take credence of the advice by the court. Perhaps it might be advisable that we stand the matters down, all of them, we hear what the judgment is, then we indicate to the court, this is the position, and then decide thereafter as to what and hear the submissions thereafter.
To me, that will make a lot of sense, because by then we'll know the judgment is already out, the judgment says A, B, C, and therefore, moving forward, 1, 2, 3.
Perhaps, may I request that then the matter stands down? All the matters will have to stand down, and we'll await that judgment. It might have an impact on the court's ruling of whatever application.
Mr. Dlamini,
Your Worship,
you seem to be over
Your Worship, I have difficulty in it. What purposes will it serve? The judgment in Eswatini. What purpose will it serve in this matter?
But the writing is on the wall.
What is the writing, Your Worship?
We'll know what the judgment is, and then we'll take the matter further from there. The judgment can go either way. It can be for or it can be against. And then whatever the judgment, or whichever way the judgment takes, it will inform us what to do.
I'm in the hands of the court, then, Your Worship.
The last time I checked, the court doesn't have hands. But we can stand the matter down.
I'm of the view that let's stand the matter down until we hear of the judgment. We are in a technology advanced times,
yes,
when we can hear what's happening in the other country in no time. Matter stands down until later in the day. I have a matter in Tuba, but I will have to contact them and tell them that
Thank you,
I won't be able to come through to them.
Thank you.
Mr. Motsoane?
My apologies, Your Worship. My profuse apologies. I'm a bit worried about the spillover effects in respect of this matter into the other matter that is still going to be called, involving accused number 1 and the other 4 accused. Most probably, Your Worship, if parties can be heard, so that one can make an appropriate determination whether or not is there a need to wait for the judgment at 11:30. But as my learned colleague for the state correctly submitted that the judgment is at 11:30, before 5 o'clock last night, the instructing attorneys in Eswatini did call saying Judge Masugu's secretary has indicated that the judge, confirming that the judgment would be handed down at 11:30. The only request I'm making, Your Worship, is that if the parties can also be heard in the other matter, so that this honorable court can have a bird's view whether or not there is a need to stand the matter down pending the judgment by Honorable Judge Masugu in the Eswatini High Court.
Am I understanding you to say that the other matter involving the five accused should also be called, and I hear your arguments?
Your Worship, on record, there isn't any indication in respect of the other matter whether the state would be seeking an adjournment. There isn't a reply from the other party, particularly the defense. What? Your Worship, that is the main reason why I stood up, just to indicate to the court that listening to the ruling that has just been made to stand the other matter down, it comes across as having spillover effect in another matter. It is on that basis and strength, Your Worship, that...
But the argument that is going to be advanced in that matter, depending on whichever way the judgment is going to go, is going to be the same as in this matter, is it not?
That's the backbone of my argument. In the other matter, it may become apparent after having heard the parties that with or without the Eswatini judgment, a determination can be made in whatever the state will be asking in that matter.
Whatever I submitted about this matter, is just, it will spill over on the same reasons for that matter. So the judgment, the ruling for 11:30 will be relevant.
I'm of that view.
My colleague made certain submissions legally and factually, which we did not reply to in the other matter. But in this one, Mr. Dlamini, on behalf of accused number 1, did reply to those. So it is my humble submission, Your Worship, that perhaps for a balanced perspective, that the other parties be heard in the other matter. Otherwise, we have only the submissions by the state that are now being transplanted in the other matter without the reply from the parties.
But you will have the opportunity to argue in that other matter when it is called. I mean, the argument in this matter regarding the Eswatini matter may be transplanted to the other matter, but that other matter is different in that all accused in that matter are in custody. So I see no reason why, Mr. Mlocho, with respect, that I should hear you in the other matter as well, which is still going to be called, where I'm going to hear you in any event.
Your Worship, without coming across as arguing in the court, I will leave the matter in the hands of the court. It's just that the only concern I had was the presentation by one party, thinking that perhaps a balanced perspective when there is reply from the other parties.
I promise you, believe you me, I'll listen to you, I'll hear you when you argue in the other matter. That's my promise.
As court pleases.
Matters to stand down until later.